In this video, we're going to be talking about part suitability. Part suitability is pretty much similar to the part 9 grounds of refusal, but not exactly the same. It's not only that they've introduced some new things, it's the manner in which these new things are going to be implemented that actually makes the difference. Let's get into it. We're going to be talking about deception, criminal convictions, previous breaches, and we're going to be talking about how it's implemented into the family and private life aspects. Now we're going to start off with my favorite topic, deception. There are two circumstances within deception that we're going to take into consideration: entry clearance when somebody comes into the country, and leave to remain when somebody is making an application from inside the country. With entry clearance applications, your application must be refused if you have made an application and within that application you gave false information, false representations, false documentation, whether it is material to the application or not. Now this is a very interesting point because there's an upper tribunal case of Beskin, and what Beskin effectively says is, if there is false information, documentation or representations, then those false elements must result in the applicant receiving a material advantage. And if there's no material advantage, then technically there's no breach. However, I, having done immigration for as long as I have, can foresee a problem here because I don't believe the caseworkers will be able to differentiate these two things. And it's quite likely that the applications, or a lot of applications, will be refused just because of this one aspect. Secondly, if you are making an entry clearance application, your application must be refused if you have failed to disclose relevant facts. Now, the second part of this is applications that are made within the country. Applications from within the country may be refused, and the criteria is exactly the same. So false information, representation and documentation, and non-disclosure of information, all of this leads to a discretionary refusal. Now, although we're saying it leads to a discretionary refusal, there's one thing that you should know. When we're talking about deception, the interpretation that the Home Office had when they're making their decision is that the decision maker, i.e. the caseworker, must look at it and be satisfied on the balance of probability that you have tried or have deceived the Home Office. Balance of probability is a really interesting standard because what it means is that the decision maker has to make a decision that it is more likely than not that you have tried to deceive the Home Office. However, that's been changed. That's become a lot more onerous for you, the applicant, because now the decision maker simply has to look at it and be satisfied that you have tried to commit deception. Now you might think to yourself, there's no difference between being satisfied and on the balance of probability. Oh my gosh, there is a huge difference. On the balance of probability is an actual assessment. Being satisfied, on the other hand, is a very subjective way of looking at things. If the decision maker is satisfied that you have committed deception, that is all that is needed. They think that you've committed deception. Refusal. My second favorite topic, criminality. If you have committed a criminal offence, whether inside the UK or outside the UK, and has led you to have a custodial sentence of more than 12 months, no matter when it took place, your application will be refused. That's an interesting one. Then, if you've committed a criminal offence, whether in the UK or outside the UK, no matter how long ago, for which you received a custodial sentence of more than 12 months, your leave must be cancelled. If you have breached an immigration rule by way of overstaying, there will be a mandatory re-entry ban. If you have committed an offence that is less than 12 months in custody, including out-of-court disposals, which are usually not very serious, if you have committed an offence like that, the Home Office will still take it into consideration, but it is a discretionary refusal. Now, what does all this mean? It means that if you have committed an offence, it is going to be virtually impossible for you to come into the UK. And I want you to remember that this also applies to Appendix FM. It also applies to family applications, whereas previously this did not. Breaches. If you have breached an immigration rule by way of not following your conditions, Whether in this application or a previous application, your application may be refused. What that means is if you came into the UK as a skilled worker and you did not work for the first few years up until you made another application, and then you continued that application up until the ILR point, and we'll get to the ILR point in just a moment, your application could be refused at any point, including and up to the ILR stage. Now, anyone who has ever done an application with me will be taking a sigh of relief, because the first thing that we do is encourage our clients to come clean about their immigration history. Because if they come clean about their immigration history, they are starting afresh. And this is the only exception that the Home Office provide under this. The Home Office say, if we have given you a previous successful application in which you disclosed your issues, then those issues won't come and haunt you. However, if you have not, and they discover that there have been breaches in the past or non-following of conditions, they will refuse the current application, which is very, very onerous. I know my clients are all taking a sigh of relief. They never have to look over their shoulder again, because every single application that we did for them, we disclosed every single issue, and they got their leave despite that, which is brilliant if you ask me. Anybody else who has skeletons in their closet, watch out, because the Home Office could potentially refuse your future applications. And then we've got overstaying. Now, overstaying is an interesting one. It's a bit of a toughie, because the Home Office's exception to overstaying is if it's an overstaying period of less than 30 days. They haven't mentioned anything else. I'm pretty sure we can make some human rights arguments to that effect. However, at the moment, it's saying that they may refuse your application if you have an overstaying period of over 30 days. I don't know how that's going to come into effect in relation to private life rules, and where we're talking about people who've effectively been legal and illegal in the UK for an extended period of time, such as 20 years, or I don't know how this is going to implement in situations where there are exceptional circumstances, but we're going to be talking about exceptional circumstances, and we'll kind of get into it. How it's actually going to work, the only way we can tell is in practice. And then a third part of the breaching is illegal entrance. When somebody enters the UK illegally, we already know that they are precluded from being able to apply for naturalization. However, now they are also precluded from being able to make an application in country for a extension, let's say, for instance, because their illegal entry is a discretionary ground of refusal. Now, I'm not entirely sure how they're going to apply this to people who are refugees, but now the tricky thing here is before these implementations, you were able to go all the way up to ILR, get your ILR, and then you were barriered and you weren't able to get citizenship. Now they're going to stop you a whole lot quicker than that. When you make your application, you've entered the country illegally, you have to be able to show exceptional circumstances. You have to show arguments, otherwise your application may be refused. And finally, we've got deception in a previous application, and we've discussed deception at quite some length, so we won't be discussing that. However, there will be developments in this and follow, because I'll be doing more videos on deception. It's one of my favorite topics. Now let's talk about family applications. Family applications are the applications where these rules did not previously apply, but now they do. Family applications are the kind of applications where normally we'd apply for exceptional circumstances if the person didn't have a right to remain in the UK. Exceptional circumstances are effectively this: you have a relevant partner, child, or another family member, and these people will suffer unjustifiably harsh consequences if your application is refused. That is the bare bones of what exceptional circumstances effectively is. There is a wider criteria to this, but we won't go into that. That is the bare bones of it. Now, in a normal situation, this was our fail-safe. This was every other person's fail-safe who has been in the UK for extended periods of time and has relevant qualifying children. Relevant qualifying children include British citizens, by the way. Now the Home Office may accept these applications. However, they will not accept these applications if the person has had, number one, a criminal conviction inside the UK or outside the UK that led to a custodial sentence of more than 12 months, is a persistent offender, is somebody who has committed an offence that has caused serious harm. These people will always be refused, despite the fact that they might have a relevant partner, child, or other family member who are going to suffer unjustifiably harsh consequences because of the refusal. Despite that, these people will not be accepted. Now let's talk about settlement. We can already see that a lot of people are going to be precluded from being able to even get to the settlement stage. But let's say, for example, you get to the settlement stage. The Home Office will refuse your application if they find out, number one, you have been involved in a sham marriage. You have given false documentation and have deceived the Home Office. We've discussed this previously. You have a litigation debt with the Home Office, which means you went to court, you lost, and the judge ordered costs against you, and you haven't paid those costs. Or you have an NHS debt of more than 500. The Home Office may refuse their application, and that can cause a lot of problems because sometimes people have children in the UK whilst they're illegal, and that racks up an NHS debt. And when we're talking about NHS debts, the NHS charges 150% to someone who is not a national in the UK, which means whatever the cost is, 150% of that is what is charged effectively on a private basis to these people, which means £500 of debt is not difficult to get to. In fact, it can easily get to thousands and thousands. Just to give you some sort of context, I always give this example where a client of ours came to us and said that their mother-in-law's visa had been refused. So we applied for it, and she was an elderly woman. It got accepted. She came into the UK and she passed away in the UK. NHS debt was £56,000. Just because they tried to give her treatment just before she passed. So it can rack up really, really quickly. And finally, we've got breaches of conditions. Let's go back to our skilled worker example. Skilled worker comes into the UK and doesn't get the hours that they are contracted. A few years pass, they get another skilled worker visa and they remain in the UK. Nobody notified the Home Office throughout the entire period. If they get to the ILR stage, that is going to be considered a breach of their condition. If the Home Office look back and they discover that there's been a breach, they will never get the ILR. And at the same time, they will never be able to progress because of the deception. Now, will these changes apply retrospectively, or will they only apply to the people who made their application after the law was implemented? Unfortunately, it will apply retrospectively. So what that means is people who have already made their applications and their decisions haven't come through, affected. People who are going to make their applications in the near future, affected, which means previously, if you've ever done anything, it's going to come and haunt you if the Home Office find out. If you're applying for ILR, you are also affected. The suitability criteria applies across the board to any and every applications that have been made and haven't been decided, and applications that are going to be made in the future up until it changes. If it changes. Those are a lot of changes, and some may argue that they are draconian in nature. However, remember, it is still early days and we don't know what aspect of that will get litigated upon and might change. But don't sit back and bank on that, because you should start taking action now. Feel free to get in contact with us and we'll be happy to help.